seniors have already told us.
Yeah, so many of you are
Yes.
telling me your name, for
Yes,
the purpose of the record. Yes.
Mr. Mulako.
Mr.
Mulako. Yes, Your Honor. Your Honor, not to repeat what my learned seniors have already submitted before this court, I would only urge this court to ask itself two fundamental questions. The first one being, Your Honor, as the office of the DPP been involved in the prosecution of this matter? Your Honor, I'm sure this court will come to the conclusion that it has not been involved. Your Honor, the second question, which this court must ask itself, and us as the interested party do actually ask ourselves, is that why has the office of the ODPP not been involved as is required by law in prosecution of all criminal matters? That is all, Your Honor.
So I think we are done with your submissions of the directions. Now, there is the question of whether you have the capacity, whether you are quota.
Yes.
And you said that there was a matter similar, a matter raising issues similar to what have been raised in this application. You've not mentioned what transpired before the High Court. To me, that is important. I should know.
Thank you, Your Honor. An Okwita, Chachamita, where we were seeking to stop the arrest, prosecution, and the continuous investigation of Honorable Stella Atambo, the learned judge granted the following orders. That in the interim, and pending the hearing and determination of this application, a conservatory order is hereby issued restraining the respondents whether by themselves their agents, officers, or any person acting under their instructions or authority from arresting, detaining, charging, or arraigning the petitioner in connection with or arising from the impugned search, seizure, or any related investigations. On the 10th of June 2025, before the learned judge,
thank you for that information.
specific to audience. We have not dealt with the question in the High Court about audience. We have left it before this court to know whether they have audience. That is the only question that we are dealing with. But if the court, in its wisdom, it can defer the ruling about this until after the judge pronounces himself. We have no problem waiting for the determination of this matter because the question is about audience.
Constitution properly, you will find that there are institutions that enjoy. The Inspector General has independence. And may go further, that there are institutions even outside the government which also have got independence. The bar has got its own independence. And what is happening currently is that the Anti-Corruption Division is attempting to exercise powers that does no moral authority or constitutional authority to exercise at all. And that's why we are opposing or telling the court that do not permit them even to open their mouths at all. So far as we are concerned, they are trespassers before the court. That's all that I wish to say.
Client, the Honorable Stella Atambo, we did move to the High Court with most urgency, seeking for conservatory orders that the EACC or any person acting under its authority be granted conservatory orders against any arrest or any prosecution of the Honorable Atambo until the constitutional petition was convinced to grant us the conservatory orders until June the 10th. And when we went to the Chief Magistrate Court at the Anti-Corruption Division, we were before Court 1 for directions, and we put up serious arguments with respect to locus standi of the EACC, who fronted themselves as applicants before a court of law. Yet the Constitution under Article 157 is very clear that that is the constitutional reserve of the Office of the Director of Public Prosecutions and Public Officer of the DPP alone. We indicated to court that the EACC does not have audience to address court, nor are they the proper party to institute any proceedings with respect to prosecution, because that is only for the DPP. And the wording that the Constitution has used is shall. Only the DPP shall prosecute. And therefore, we are waiting for a ruling that has been reserved to tomorrow. And the EACC has not yet been granted any audience until the court can give directions on whether, in fact, they do have capacity or not to prosecute an application that they are investigating. In their documents in court through a notice of motion application, They indicated to court very clearly that they are the investigators. It then came to the surprise of the defense advocates then why it is the investigators are prosecuting their application. Yet the DPP exists and they have not been mentioned, nor have they been involved at any stage in their ex parte application. Therefore, we are hoping that in the fullness of time, which is tomorrow morning at 9 a.m., that the court will pronounce itself according to the submissions that we submitted before the court, and in line with the provisions of the Constitution and any other law that is practiced in Kenya. Thank you.
EACC came to this court. The first instance, they came as investigators. Serious issues were raised about how they conducted themselves in that investigation. Serious issues were raised on who they, whether they had come there with their bona fide intentions or they were malicious. After this application had been presented to court, they decided now to come back to court as prosecutors. The same people who signed those affidavits to investigate and to make such warrants are the same people again appearing as advocates. The law does not allow that. There's that independence, as my senior Dr. Kamino said. So at what point do they have the powers to metamorphosize? How do they change? Are they chameleons? Wherever surface they land in, that is what they do. They cannot be the investigators, then they become the prosecutors, then they become the jury in their own matter. And that's why the independence of these offices is there. So all of a sudden, them not being gazetted, them being appointed by the Attorney General or the Director of Public Prosecution, what powers do they have? Are they the same people who are now investigators and also give directions on what is to be done? I tend to think that the EACC seems to have lost direction, and we need to be able to consider whether we really need them in our lives anymore. As I said last time, we need to disband them, cut them into pieces, distribute those pieces. These people are no longer useful to us. First of all, they are malicious. Secondly, they have lost direction. Thirdly, they are giving themselves mandates that they do not have. And then, do you want to trust them anymore with your lives and your daily duties? You cannot. So, I tend to think that we seriously need to consider whether we need them in our lives anymore, or whether that it's taxpayers' money that is going to waste. These guys are just busybodies.
Now, to crystallize this thing that we are talking about, the law, is that Section 85 of the Criminal Procedure Code gives the ODPP powers to prosecute. Those powers have been donated, gives the ODPP powers to delegate prosecutorial issues to any other person not being the ODPP himself. So that is why we have several officers who are lawyers employed at the office of the ODPP. Now, for one to qualify, those have got nothing to do with what we are claiming in court. That the EACC, who have in their employment counsel or advocates working for them, those advocates who have been employed there have been employed to give guidance to the investigators on what they need to do in their investigations, but not to come to court to prosecute. Once they assemble their files and once they feel that an issue has arisen requiring to be prosecuted in court, they prepare their applications in the name of the ODPP. Then an officer, an advocate employed by the ODPP, comes to court to ventilate the issues that the investigators have come up with. So it is not available for the EACC, through their in-house counsel, to come to court and purport to address the court as investigators, also as applicants for the party. Then, that is where our senior Dr. Hamino said, independence of institutions. It's like myself or ourselves going to court to present an application wanting something to be seized or to be done like they did on the Honorable Stella Atambo. Now, the other issue that we need to address on is how they brought these issues to court. There was no disclosure of facts who the respondent was. Remember, they said it is Bonareri N, without ever disclosing who this Bonareri N was.